Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another episode of our show. Today, we have a very special guest for you. We're talking to Grace St.Clair. Grace, welcome to the show.
Thank you.
Grace is an estate planning attorney, and we're going to go over something that is so important that we talk about during the show. We've mentioned it, but we've never really nailed it and gone through it. So we're going to talk about the documents that are part of an effective estate planning and why they're important. So Grace, without further ado, I would like to, if you can define for our audience some of the important documents, like what is a last will and testament?
Mm-hmm. I think what's interesting is we all talk about them as trust, like a trust. What is in my trust? And everyone thinks that's one thing. Mm-hmm. But really, you'll end up getting a binder of a series of documents. And one of them is a trust. But there are other things that go into it because the trust itself is only the box that all the property goes into. And it describes how that property is going to be managed. But by itself, that trust can't operate without a trustee and other documents to make it work. So it's actually, I call it a trust package in my office, but it is more than one document. So it's helpful to know what they are. So a last will and testament is really the will. And people have heard what a living will is. Sometimes they've heard a will, but the last will and testament is the old English wording for a will that's by itself. So yes, if you own under $186,500 today, you can pass it with a will. And the will itself does have to be probated, but there is no probate if you own like a small enough amount of assets. But in California, we all own, if you have any real estate, obviously, you're going to go through probate because you can't find a house for under $200,000. Even in like the 55 plus communities that have those mobile homes, those are even about that price now. So you can't find anything less than that. So probate is an issue, and having a trust, when you have a trust, the property passes through that box instead of through your name personally, and that's how you avoid going to probate. So a lot of people don't realize that, yes, you have to probate that will. So even if you create one, it has to go through that court process. I just finished up one yesterday that was 3 years long. Why is it so long?
Wow.
Well, first of all, the aunt who actually provided the property wrote a little bit on her napkin, and it was in Spanish. So she said, my sister gets it and her son gets it, but it was all in Spanish. So we had to first make sure that that napkin was a valid will, and it's called a holographic will. And so we had to go through the court process to prove that that worked. After that happened, then we had a series of papers we had to file. So unfortunately now, since the pandemic, we have 54 cases on the morning calendar instead of 25 like we used to. So more and more people are going through probate. I really think they should change that, but I'm not, empowered to get that done. So unfortunately, the law expects everyone to do it. So that's what that last will and testament is. But when you have a trust, you don't need that will itself anymore because you're not going to pass certain properties to certain people. What we have is what we call a pour over will that we can use to pour those assets into the trust just in case you accidentally left them out. Still does require a court petition. That's what's called the Hegstead petition. People may have heard that name. It's named after a case, and that particular party was allowed to pass property through their trust because they had certain things that were required. And those other things will be included in your trust package.
Yeah, so what I see a lot in my business is people who do a refinance. They take the property out of the trust and they forget to put it in. So that petition has saved quite a bit of time help people that forget to put the things forget to put the property back in the trust.
Yes.
I love the story about the napkin. I've heard, we've heard things like that, so let me ask you specific questions about that journey that you just experienced. Did you have to get a certified translated copy of the napkin? How did you, what was the process? I'm just so curious about it.
Yes. Well, first it was a very small napkin, very bare bones, but it did have the handwriting of the testator on it, which is one of the most important things. We
Right.
always have people write up in our office before they finish their trust, just a little bit about what they wanted to do in their own handwriting, so we can introduce that just in case they pass before we get it all done. But the idea is that's only a stopgap measure. So
Right.
yes, it was in Spanish, so we had to have a certified translator. So you can't just get any translator. You have to
Right.
go through the court to someone they recognize who will actually be allowed to translate that so the judge will figure out what it is. Then there's a hearing about whether or not it gets approved. And in the hearing, they go through anything that you can do to support that, as it would have been the testator's intent. And I've never had it before that, so I've had one, so my success rate is 100%. But I wouldn't recommend that, but if you have it, it's still possible to have it done, as
That
long as you
makes
have the particulars in the handwriting of the testator and it's signed. You should have witnesses, but in this case, we didn't.
That makes sense. Very nice. Thank you for sharing that story with us. Now let's talk about the role that a power of attorney plays within an estate plan. I know that the trust, it's kind of, the trust really does a lot of the work now. The living trust that we use, the revocable living trust that we have, has a lot of, but people still include power of attorneys. Do you find, how is that? Are you including those in your estate planning as well?
Absolutely, because a lot of the things have to be done that aren't necessarily part of the trust, but they
Mhm.
are your life outside of the trust. So
Right.
you need a person to take your place just in case you can't act. And it
Right.
doesn't have to be an incapacity. You can be in a car accident
Right.
and not able to do something. Your trust is a box. It only lives with an agent or you as a successor trustee.
Mhm.
So having that power of attorney is very important. We've learned this year now, excuse me, that the banks are not approving long let's say long held powers of attorney any longer. I think banks have just been ridden these past few years with problems, and so they're expecting 3 years. You need to have that updated every 3 years. A new power of attorney signed every 3 years. If you have been using it for longer, I would definitely record it, because that would be sufficient in that case to have it recorded to tell the entire world that your agent is acting for you. But otherwise, you need to re-sign that every 3 years. So you need to go back to your lawyer and make sure it's done right. We include a general power of attorney, which is for all personal assets, non-real estate. No, I'm sorry, real estate works with those, non-health. Then we have an advanced care directive,
Right.
which is very important for healthcare. We also include the waiver for the HIPAA waiver, because we still have issues with HIPAA.
Right.
And we need to be named as a waived party, as an attorney, just in case there's capacity issues with someone. That's what that's for. Otherwise, it's $25,000 every time. The penalty is $25,000
Wow.
every time someone tries to use your protected information without your permission. So we include that. But I'm also including now the uniform power of attorney. I don't like the uniform power of attorney myself, because it doesn't explain anything. And of course, being a lawyer, I want it all explained, right?
Yes.
The banks are insisting on using that because they don't want to send everything up to their legal department. But
Right.
what happens is when you check those boxes, the very first one is real estate transactions. If you check that box, then your agent has the power to handle real estate transactions. But what does that mean? Does
Right.
that mean your agent can sell a house for you? That it doesn't say that. Does it mean they can borrow money for you? It doesn't say that. Does that mean they can sell the house out from underneath you? It doesn't say that. So the general power that I use is 30 some odd pages long, and it explains
wow.
all those powers and what they are. And also, if you're a business owner, you need to think about your business cannot operate without you. Many
Right.
times we have ourselves and a spouse and a business and maybe one other person, and it's all between us, and we run our business. We don't think anything of it. Sometimes multi-million dollars. And yet, if they don't have a succession plan or a power of attorney or a key person who can act on their behalf, they can't get anything done. So it's also very
Right.
important for a business to have those powers of attorney.
That makes total sense. That makes total sense. Now, let's talk briefly about, the guardianship for minor children. Obviously, you're always hoping that when you are doing your estate plan, by the time comes, your children are adult and you don't have to worry about that. But how do you advise your clients when it comes to that? Selecting the guardian, number one, and then how do you put that, within the estate plan?
Mm-hmm. Well, that does go through the will. So you want to remember what we learned so much about Michael Jackson's case was because he had some children. We learned about that because that's public record. And unfortunately, one of the worst things his attorney did was he said, a trust is something only wealthy people do, which is not true in our case, because definitely California, I guess you're wealthy if you own a home in California in his mind, but you definitely have to have that trust in place. But we learned a lot about his problems because the will is unfortunately public record, but you have to have those guardianships to go through the court. So you want to pick someone that you believe could take care of your children like you would have, if you were capable of doing that. So it's same thing. It could be, in our case, California, we could be on one side of the ocean because we had an earthquake, and now we suddenly have some more, property that's now beachfront. That could be what the unavailability is. So I don't know how the courts will work if that happened, but we'll see. But anyway, you have to think about those things. It could be a very minor thing that requires you to have a guardianship named. We always like to also include for our young families a limited power of attorney for babysitting. Many people leave their kids with their grandparents, and they have no legal right to take your kids to the hospital. And how many times have you heard the story where little Johnny has a marble somewhere where it shouldn't go? They always do that. So if you're having family or friends even take care of your children, they need a limited power of attorney to do any medical issues that they need to handle while you're gone. So if it's a weekend, for sure, we give that to the family so that they can copy it and use it whenever they need to. But something very important for young children.
That makes total sense. One of the things that I wanted to ask you, first of all, I'm going to compliment you because all your explanations are very crystal clear. So by looking at your bio, you mentioned that you had experience in a big firm when you started practicing law. And I kind of wanted to talk to you about how has that experience shaped your approach to estate planning?
Well, I actually, the shaping came from when my dad got into a probate, and I found out the hard way that it didn't work right, which made me feel awful. I thought there's people out there paying for something that's not working right. But when I was at O'Melveny, I learned how to practice law extremely detailed. Every one of our partners was brilliant, and you had to go into their office and have cohesive, full sentences and be able to speak to them in their way, or they would never listen to you again. So there was a lot of pressure there. But we definitely practice at a very high level. And that's very important in estate planning. The details, it's all in the details. One detail left awry, as you mentioned, with the refinance and the deed not getting back in, it caused you everything you planned in your trust to go awry. So we actually also have what's called a client care program in my office to keep our clients close to us, just in case they have changes. We can do minor changes with powers of attorney, addresses, phone numbers, because you want to have the right agent in place. So we can change those after the end of every year to try to figure out if there's been a change. That's very important, especially when you have those deed issues. Escrow will take the property out and refinance, but they don't always put it back in. And that's exactly what happens. You get busy, you get all those papers. I did it myself when we bought our house. I signed everything and put them in a pile. That's what everybody does. So if you have a trust, you have to make sure that that deed gets replaced into your trust. Delivery is very important. And the cost of going through a Hagstead petition is half of a probate fee at least. So you want to make sure that you have that done. So we do those for free. If you refinance, we will make sure when you call us that it's in there again. And it's very simple to do, but it has to be done.
That's great. That's great. So basically, what you experience with your father's estate is the fact that all of this estate planning that is done, and some of it it's done, some of it it's not done. But even when it's done, if it's not done correctly, it ends up hurting. So, what are some? Obviously, through the years of experience, I'm sure that you have put some checks in place. But my question is, how often do you reach out to your client? Like you mentioned, your client care. Do you reach out to your client to make sure, hey, has anything changed? Has anybody got divorced? Do you have a birth and things like that. How often do you find that it's useful to reach out to your clients with those requesting those information,
Yeah.
rather?
If you're a member of the client care program, we do it every year, but if
Okay.
we do reach out to our clients on a regular basis, we like to be connected with them. We like to send out a newsletter. The newsletters are sometimes interesting legal things. We also send out summer tips and tricks, special recipes that we might have found. We send out fun things that are happening in the community. I'm also very involved in charities, and so I'm always sending things like that
Oh,
out.
that's great.
But it, for in general, the trust itself, it's usually at the beginning of the first year while you're getting ready for taxes, we remind you to let us know if there's something that we need to know about. And people's addresses change, people's email addresses change.
Right.
All of us do it. It's very important. And one of the things that we also do with our client care program is we allow you to have a digital assets account. A lot of us have most of our assets coming through our computer and our phones. And so we are able to transfer the phone and the computer to the rightful party through this digital assets account. It's very important. We actually have had one extraneous brother, I guess, come down from Indianapolis who actually had a history of embezzlement with the family. And he tried to, the first thing he wanted from his two nephews was the computer and the phone. And luckily we had that account that said, I'm sorry, these go to the sons and you don't get them. Because he would have, that's where all the retirement information would have been about how to collect her retirement money. And it was surprising that she passed first.
That's very interesting. Thank you actually for bringing that up, because I do want to talk about digital assets. So what are some of the things that people can do to safeguard when they come to you? Obviously nowadays, I mean, people can have Bitcoins, and there's also a whole thing about, intellectual property, so many types of ownership of assets that a person can have. How do you advise your client when they come to you to sort of like organize those things?
Yeah. Well, one of the things I should have said, I was going to say a second ago, is basically those documents and the interview. I need to have your real estate for sure, because that's going to be in the recording. I need to know also, though, all of your financial assets, your bank account. And the last interesting one I had was when we were doing the signing. I said we need to keep going through the funding instructions, which is one of the documents that we provide. The revocable trust, the funding instructions, and the summary help them understand in layman's terms, the summary and the funding instructions, how to do things after we leave. But I always participate in the funding because of my dad. I saw him not get things funded. People still leave it in your trust for you to do, and nobody does it right. And we forget, we put it on thank God, that was such a long process doing that. I'm so done with this. They put it on the shelf. But he had $200,000 worth of cars and motorcycles when he added them all up outside of his trust. I said, well, you got to put those in your trust or they're going to go through probate. What? The DMV? I said, absolutely. You can't just we have to now open a probate for those. He had like 3 Harley Davidsons and a couple really nice cars, an old Corvette. And, those things add up. They get very valuable over time. So no one ever asked him that. I said, well, we have to know all of your assets. I need everything, because you could have $100,000 in your checking account. That added up with a couple of cars could be enough. So that's why I make sure I find out exactly what people own. It's not just the real estate. A lot of lawyers are uncomfortable with that because they don't think of those other assets, and maybe they expect you to do it. But you need to know for sure if it's your job or the lawyer's job, because if you have to do it, you have to make sure it gets done. Or you could have money outside of your trust.
Very nice. That makes total sense. Let's talk about your journey a little bit, because this always fascinates me. How did you arrive? Was it your father's experience that led you to eventually start practicing estate planning? Was that the catalyst?
Yeah, pretty much. I mean, I was working downtown. I was working 9 to 3 a.m. on a regular basis.
Oh, wow.
It started becoming 9:30 because I couldn't get up because I was, working too late. But it was a lot of work, and there's nothing to displace the training mechanism. It was a huge, great experience for that purpose. But it's hard to work those kind of hours. And right about that time, and I was making every day, which is not as exciting, I guess, as helping families, but to each his own, right? But those banks would call on Friday night. They need something on Monday. I work all weekend. Oh, they don't need it until next week. So at that time, my dad was going through this probate, and he's an only child. And the houses were, there was a small house, it was a house in Ventura and a small bank account, not a ton of money. And it took 2 years and $26,000 to get through that process, and no one was complaining. And I was like, what went wrong here? Because there was some kind of a trust on the assessor's records, but not in the recorder's office. So we had to go through probate. And that's $2,000 a month. And I know that was a long time ago. But the idea is, who has $2,000 laying around for 2 years to invest in something like that? Yeah. It's a lot of money, and you'd be surprised how much time and aggravation it can create. And so I just felt like at that time I was trying to create a life for myself. I was had a fiance now, and I was like, I don't want to work like this for the rest of my life. I was on a huge deal for 6 months, and I remember sitting looking at him like, I haven't seen you in 6 months. I don't even know who you are. And I spent all this time trying to meet you. So about that same time, it seemed like a perfect challenge, a perfect thing to do, to kind of start doing estate planning, and it fit right in. I have that story, so I totally know what it feels like to go through that process. And my family thought they were all protected, but I'm sure it was one of those things where you had to do something, that they cut the price, you file this, you do that. But I've also had that in 2017 in my practice, where a man with Parkinson's didn't end up finishing and filing the paperwork that he needed to file. And luckily, when he got so feeble, his son asked me to come in and do something. And so when we started opening the box, I saw the trust sitting there with all things that he had signed in perfect handwriting that were still sitting there from 2008.
Oh, wow.
So he didn't do it, because he probably just put him in the thing and didn't even think about it. Put him in the binder, went on with his life, or he was getting worse. So we had to file those with the investment company, because he had done an IRA trust at that time. So it's very important that you have someone guide you along the way. I mean, even with the trust administration, when someone passes, I know a lot of people think, oh, I can just do this myself. And they give all the cash before they really know how much they have to spend. And then they don't have the money to provide other services for the trust administration. So it's really such an easier breeze to go through with a qualified attorney to lead you along the way, so you're not making mistakes with your fiduciary duty, but also not going through that process that is not fun alone.
Yeah, no, that makes total sense. That makes total sense. Okay, great. This has been so helpful and so interesting. I really enjoyed talking to you. But before I let you go, I have a list of 30 questions. I'm not going to ask them all to you, but I want you to pick a random number of this list. This is like back of the card. My audience loves to know, a little bit about a personal preference of our guests. So if you would indulge me and pick a number between 1 and 30, I will ask you that question, so you'll be responsible for what I'm asking you.
Okay, 17.
All right, 17. Okay, why were you given your name?
Oh, that's a good one. So my name, I was born as Grace Elizabeth. I was named after Princess Grace and Queen Elizabeth.
Oh,
it has
wow.
a lot to do with my family. My father's mother is fresh off the boat English. She definitely was 100%, and actually left England when she was 8 years old. She was summoned by her dad to come to California.
Oh, wow.
So it was in honor of her history. And then my mom loved Princess Grace at the time. So it was Grace Elizabeth. That's
wonderful. That's wonderful to know. Okay, one more thing before I let you go, which is, what is the best way for our audience to get a hold of you?
I'm Grace at qualityestateplanning.com. That's my email address. You can call my number, 310-374-5479. Either one of those works. You can check out our website, and also those same numbers are there. Again, it's qualityestateplanning.com in the South Bay here.
Perfect. Thank you so much for your time. Thank you so much for being on the show. I really enjoyed talking to you. And maybe I will reach out some point and have you back, because we really just scratched the surface. Obviously, there's so much to talk about when it comes to estate planning. So
yeah, for sure. I'd love
time.
to. I think getting the message out is the most important thing, and people need to understand these are areas you don't learn about unless you're stuck in them. So it'd be helpful to have that. I'd love to do that.
True. Thank you so much. Bye, everybody. Thank you for joining us for this show. We'll see you on the next episode. Bye-bye.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The Probate Realtor Matias Baker Masucci is a licensed real estate broker in California, DRE number 020544763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.